I'm issuing this video in public interest because I'm getting so many calls and there's a lot of confusion, I'm told, about what has been dismissed. So I have received a mail from Supreme Court Registry which says the review petition has been dismissed. Writ petition is pending, as we all know. The writ petition was filed requesting review of the order of Supreme Court dated 13th May 2022, by which Supreme Court says that the jurisdiction would lie with the government of Gujarat, because as per that order, the court says the appropriate government is state of Gujarat, not state of Maharashtra. We challenged that. We sought review of that order by saying no, as per the consistent position of law, the very unambiguous provision of section 432 CRPC, the appropriate government would be the government in which state the conviction order has been passed. Since in this case the conviction order has been passed by the state of Maharashtra by the special judge Mumbai, therefore the jurisdiction would be of state of Maharashtra as an appropriate government. This was the concept of the review petition. Review was for the purpose of seeking review of the order of Supreme Court dated 13th May 2022. The remission order, the release order of the accused, of the 11 convicts, is not subject matter of the review. It is subject matter of the challenge to the same, is subject matter of the writ petition, which is still pending. So yes, it is a setback when it comes to the fact that review has been dismissed. Order is yet not out. I have only received a mail from Supreme Court Registry conveying me the conclusion, that is, the review has been dismissed. I would not be surprised that it would be an order saying the petitioner is at liberty to raise all the legal issues which have been raised in the review petition in the writ petition. In all probability, this may also be the order where the court is saying that you are at liberty to raise all these issues and we are just stopping the multiplication. So in all fairness, there is no setback. Yes, legally, since we wanted that order to be corrected of 13th May 2022, because the two issues considered and decided in that order, which says the state of Gujarat is the appropriate government, and the court said the state of Gujarat is the appropriate government because the crime was committed there. And so what, the conviction has taken place in Maharashtra. This, in our humble opinion, is an incorrect opinion, incorrect view on face of 4 judgments of Supreme Court, the consistent position from 1976, reiterated by the 5 judges bench recently in 2016, and also on the face of the very, very unambiguous provision of law under section 432 CRPC, which reiterates and which maintains the position of the earlier CRPC. That time it was section 401, which clearly says the place where, the state where the conviction has taken place. And admittedly, in this case, the conviction has taken place in Maharashtra. Once Maharashtra remains the state and the appropriate government, then you know the policy there is, because it is a case of 2 life imprisonment. Each and every convict was given 2 life imprisonment, and therefore there, as per the policies and the fact that the pregnant woman was raped, that the women were raped and murdered, and there were minor killed, 8 minors have been killed in this case. There, the minimum sentence in Maharashtra, as per their policy, minimum sentence to be undergone is 28 years. So we were challenging, we were seeking review of that order because of the legality aspect. But remission, the legality, the correctness of the remission would still open for discussion. There is no setback when it comes to merit to be tested of the remission orders and whether the state of Gujarat could have taken it. Simply because Supreme Court has said by their order of 13th May 2022 doesn't mean that the state of Gujarat was forced to take up this matter when they didn't have the jurisdiction. It was for state of Gujarat to go for and file the review petition or clarify it. So the issue completely remains open. No setback on the merit of the case. only one petition on the legal aspect has been dismissed. Every issue remains open, and I'm still hoping that the order is not yet out of the review petition. I'm still hoping that in all probability the order would be that since we already have the writ petition, we are seized of the PIS file in the case, all issues have to be examined there. All the issues are open for the petition to be raised there, and therefore review is dismissed. Maybe this may be a case also. We need to wait for the order to come. Meanwhile, we need not to worry, honestly. And I'm issuing this, because I was getting so many calls, so much of the confusion, and I thought it in all appropriateness that I must clarify the confusion. I'm sorry for the noises around. I'm traveling. I'm on road. I've just stopped my car to just give this bite, so to clear the air. And so please forgive me and excuse me for the noises which are coming around.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.